before I start, on behalf of everybody on this side of that bench, the court, the staff, Mr. Fisher, Mr. Bailey, everybody, I'd like to take a second or two just to think about and reflect about what happened in Las Vegas last night. Because that's kind of what binds us all together. Several days ago, I came in front of you and I said, one of the fascinating things about being a juror and being on a jury is that you're placed in the middle of a drama about which you know virtually nothing. And that you're going to hear through witnesses a story. You're going to hear what they have to say. You're going to see exhibits. You're going to be instructed by the judge. And you're going to use your own wisdom and your own common sense about everything that you hear and everything that you saw. What you know to be the cause of human behavior, how people act, and why they act. I talked to you about money and greed and resentment. And I told you that money changes everything. And you know that to be true. You've seen evidence of that. You've seen text messages. $20 million, LOL. When we met, I told you I represented Markieff Morris. I told you I was going to ask you to find Markieff Morris not guilty. I told you I was going to ask you to find Marcus Morris not guilty, and I was going to ask you to find Bill Bowman not guilty. And I am going to do that in a few minutes. But first, there's a couple of things I want to focus on. When I first uttered any words to you, and it's bizarre in some respects. We sit here as lawyers and we never even look at you. We're told we're not even allowed to really have contact with the jury. We don't even really look at you. We hope that you're listening with profound humility. We hope that you're listening and getting what we say about our clients and about what happened. But we don't interact. There's so few opportunities for us to actually have a conversation. But there's a couple of things that I want you to focus on. One of them is the instructions. I'm going to go through the instructions because what the judge tells you what you have to do as a member of a jury in a 200-year tradition of jurisprudence, what you're supposed to do with instructions. I'm going to talk to you about the taint, inexcusable and unforgivable taint of Alonzo Hickerson. I'm going to digress for just a second. The state said, put that to one side, it's not that big of a deal, he's not on trial here. That is outrageous. You witnessed two witnesses raise their hand in front of a sitting Superior Court judge and tell you that somebody approached them and asked them to lie, to implicate persons on charge, facing criminal charges in a Superior Court in Maricopa County. That is outrageous. And you should be outraged by that. And it affects every aspect of this case. We're going to talk to you about the facts as we know them, the facts that we can't know, but that you can infer. And we can't know some of the facts because we don't know certain things that Alonzo Hickerson did. We know what two people testified to, but we don't know the infection that he had beyond that. And we don't know, and some of the facts we don't know because of the investigation that wasn't done in this case. At best, it was a mediocre investigation. We all have a right to rely on it to be a heck of a lot better than it was in this case. The last thing I'm going to talk about to you all is the role of a jury in a criminal case, not just here today, but across the country and in courtrooms like this from Maine to Hawaii. Initially, in the preliminary instructions, remember the judge told you that she's going to make rulings on admissibility of evidence. She's the gatekeeper, right? She's much, much more than that, but one of her primary roles is she's the gatekeeper of evidence. Her job is to make sure that what you hear is relevant and as accurate as can possibly be. That was in the preliminary instructions. And you heard her strike certain testimony. And you heard her sustain objections to questions. Because in her judgment, the answers would not be relevant or would not further the fact-finding process. In fact, And we had a lot of white noise in this case. I always refer to it as white noise. How many times did we go up there where we were sitting in front of the judge and you hear that sssss, and you can't hear what's going on? What's up there is the lawyers talking to the judge in order to try and get a basis for you to get the most accurate information possible. And critically, that came into play with the most profound and unbelievable question that was asked in this case. And it was the last question asked, and it was asked by the jury. What did Julius King and Christopher Melendez say about what happened? I'll get into that later. Presumption of innocence and burden of proof. You have the instructions. You're going to have them back in the jury room. When I first was able to speak with you, I said, and again, color me naive. We're part of a process here. You have a role as important as Mr. Bailey and Mr. Fisher, Mr. Eckstein in the court. Your role at this point is critically more important. We're done. When I sit down, I'm done. There's nothing I can do to influence what you're going to do. But you're given some instructions, and one of them is the defendant is presumed to be innocent, absolutely presumed to be innocent, that the state bears the burden of proof beyond a reasonable doubt that every element of this case is proven, and that a defendant need not produce evidence of any kind. That's a fundamental tenet of American law. If the state says you did something wrong, you have the absolute and constitutional right to rely on them to prove it beyond a reasonable doubt. One of the things that happened in this case, when we opened and told you what we were going to try and do, we had no idea about Alonzo Hickerson's statements to Mr. Halal and Mr. Miller. We didn't find that out until 3 or 4 days into the case. And to the credit of the county attorneys, they let us know as soon as they found out. But we didn't know that when we did our opening arguments to you. That fundamentally changed the tenor of this case in a lot of ways, and I'll explain it in a little bit. But the bottom line on that is that a defendant charged with a crime in the United States of America, in the state of Arizona, in Maricopa County, can rely on the state not being able to meet its burden of proof. And we talk about burdens of proof all the time, and in the instructions, it's beyond a reasonable doubt. We live with beyond a reasonable doubt. We read it every day in cases. We see it. I don't know how many of you, I don't remember how many of you actually sat on a jury. Maybe some of you did. I had no idea. But we're always trying to get you to understand, what does it mean to be beyond a reasonable doubt? Okay? I'm going to give you my attempt of what it is. You'll read in the instructions that there are 3 levels of proof: preponderance of the evidence, clear and convincing evidence, and beyond a reasonable doubt. Preponderance of the evidence and clear and convincing evidence are civil cases, money judgments. Preponderance of the evidence, for example, if you had somebody build a fence and they screwed the fence up and you wanted to sue them, and you get a judgment against them, preponderance of the evidence. It's down here, right? It's down below your knees. It's, maybe I think this happened, maybe I think the guy screwed up the fence, maybe I think the guy didn't screw up the fence. Is it more likely than not? Okay, I'm going to go with he screwed up the fence. There's a lot of evidence that he didn't screw up the fence, but there's evidence that he did screw up the fence, so I'm going to go with that. That's preponderance of the evidence. Clear and convincing evidence is also usually a standard in civil cases. It usually comes up when there's a claim of a falsehood or fraud. For example, Alonzo Hickerson is on trial for trying to bribe witnesses, and it's a civil matter, not a criminal matter. The standard of proof in a case like that is up around your gut. Am I clearly convinced that this person lied? committed a falsehood. Even though, and here's the evidence, you have Miller and Bilal testifying, yes, he did, he approached us, he asked us to lie in a criminal case to implicate people that would have nothing to do with this offense. There's testimony on the other side. It's Eric Hood saying, Alonzo never said anything like that to me. You would have to decide, if the civil case involved Alonzo Hickerson, you would have to decide by clear and convincing evidence, did he actually solicit these gentlemen to lie in a superior court? That's clear and convincing evidence. The standard for criminal cases where persons' liberty is at stake, where their future is at stake, is beyond a reasonable doubt. It's up here. If I look at this case, is there anything in this case that gives me doubt upon which I can base, upon which there is some basis in reason? It's beyond that. If there's any doubt at all and there's a basis in reason, you're instructed to say, not guilty. Our system relies on that. They rely on that, you to do that. And that's the standard. And we're always miserable. We don't know that we can ever communicate that to you, because even though we live with this standard every single day, you see it. This may be your only experience ever with these burdens of proof. Ever. The credibility of witnesses. There's an instruction regarding the credibility of witnesses. What makes a witness credible or incredible? What are their biases? What are their motives? What is it? Do they have an opportunity to fabricate testimony? And if they do, what is the basis to lie? Again, you're going to have instructions, but you also have common sense, right? You know. Human nature. What makes people do what they do? What makes people come into a court of law and embellish testimony or fabricate testimony? What is the motive behind that? Lie is a big word. Liar. Lie. We seldom, as lawyers, use that word. But in this case, we have evidence that the mentor, the guardian, the close friend of Eric Hood, actually approached two witnesses to lie about what they saw. Please lie to implicate the Morris brothers, and there'll be money in it for you. And remember when I said to Detective Santos, if Alonzo Hickerson walked through those doors, you'd have a basis to arrest him. And he said, well, I don't really know. I'd have to do a little bit more investigation. Are you kidding me? Are you kidding me? Let me say, and there are 100,000 jury trials going on in the United States right now, plus or minus. I have no idea of the number. I would wager that the hundreds of thousands of jurors listening to testimony will not see two people get on a stand, raise their hand, and say, somebody tried to get us to lie in this case. Say something that didn't happen and to implicate the Morris brothers and that we would get money for it. That is an outrage. That is an outrage. Let me tell you the difference between direct and circumstantial evidence. Direct evidence, there's an instruction, what somebody saw and they said, or what they heard and they tell you about it. Direct evidence is Dr. Halal and Jacob Miller saying that Alonzo Hickerson came to us and told us to lie, and you might get some money out of it if we did. And that's the only evidence that we have in terms of direct evidence. Circumstantial evidence is, what other impact did Alonzo Hickerson have in this case? There's 2 days between 7:22 p.m. on January 24th, 2015, and 2 or 3 days later, there's evidence that there was dozens of phone calls between Alonzo Hickerson and Eric Hood. We know that at 7:29, they had a 4-minute conversation. They had at least 3 minute more conversations before Eric Hood even talked to Detective Santos. We don't know what they said. Eric Hood said that, well, he didn't say anything to me about lying. Circumstantial evidence, and at the same time, we know that Miller and Halal say they're in conversation with Alonzo Hickerson. He's asking them to lie, and sometime during that period of time, they tell him, pound sand. Pound sand. We're not going to do that for you. Are you kidding me? We're not going to lie. The circumstantial evidence that you can infer from is that Eric Hood and his surrogate, Sharika Sharad, changed their testimony in order to keep at least one of the Morris brothers in the case. Again, we didn't know about that at the beginning of the case. We only found that out later in the after the opening. Two other things I want to talk about in terms of Alonzo Hickerson. There are two 13-minute gaps in this case regarding recorded conversations. And some of you may remember the Nixon tapes. Some of you may not. As I look at the juror, I'm in my mind thinking some of you probably remember the 18 minutes of the Nixon tapes. You may have educated fellow jurors that I'm looking at and thinking maybe they don't know about the 18 minutes missing in the Nixon tapes. There are two times that there are 13-minute gaps in this case. One is after Eric Hood lied 9 times. And then he was in a 13-minute conversation, plus or minus, with somebody. We don't even know who because it wasn't investigated. And all of a sudden the story changed. All of a sudden, according to everybody else, Markieff Morris was not involved in it, but he still tried to keep Marcus Morris involved in it because that's where the cash comes in. And then Sharika Sharad, in terms of the taint of Alonzo Hickerson, you saw the text message. Are you kidding me? I'm going to get $20 million because the Morris brothers are being sued and I'm a witness. LOL. LOL. Detective Santos, granted he was not able to extract the information technologically, but he could have read the text messages. Could have read the same text messages that you read about his witnesses. The taint of Alonzo Hickerson infects every aspect of this case. There's only pretty much two independent witnesses that saw what happened, Miller and Halal, and I'm going to get into what they said in a minute. And there are two that are not independent, Sharad and Hood. You will never know, and this is reasonable doubt in and of itself, you will never know the impact that Alonzo Hickerson had on their testimony. Whether they changed it, whether they shaped it, whether they made it so that the Morris brothers could be implicated in this case. That taint alone should cause you to throw this case out. We talk about the facts in the investigation just a little bit. Mr. Eckstein went through the facts. I'm not going to go through them on a blow-by-blow basis. He provided you with inconsistent testimony, a number of things, all of which, as he said, provided the basis for reasonable doubt in this case and for you to reach a not guilty verdict. I just mentioned that there are independent and non-independent witnesses. Miller and Halal, independent. They're not Eric Hood. They have no stake in the outcome. They're not Sharika Sharad, who has a stake in the outcome. Jacob Miller told you that he never saw Markieff or Marcus involved in the fight. He saw Markieff up by his car. He was 100% sure that Markieff had nothing to do with this. Marcus was closer, but he was not involved. Remember, Mr. Eckstein was, I don't know if this is 20 feet, is it 30 feet away? Not involved. Neither one of those gentlemen testified that on the lookout theory, that either Marcus or Markieff said, hey, people coming down here, stop it, let's get out of here, we're lookouts. That theory is bogus. That theory was dead on arrival. I like these gentlemen. I think they are profoundly and significantly wrong about what they're arguing in this case. That theory is preposterous, as is the getaway car, which I'll get to in a few seconds. According to Miller, he was never told to stop. He was never intimidated. He was never threatened. They never put a hand on him. They never raised their hands, don't go down there. Nothing like that. No conflict, no argument. They all walked back up together, and Miller was telling people, okay, show's over, time to get out of here. Get in your cars and let's go. Because there was a lot of people around. That's one of the few things that Sharika Sharad said that I think was probably honest, was that there were a lot of people around. They could have seen this. None of them corroborated what she said happened. Mustafa Halal, he heard there was a fight. Woman comes in right after the game. That's what he said, right after the game. Didn't say it was the Morris twins, it just said there's a fight out there. So he comes out with Miller, who's a little bit in front of him. He sees both of the twins in the vicinity of their car. You can draw it in the diagram of where it was, in the vicinity of their car. He ran right behind them. Never lost sight of either one of them. Again, they never yelled out, hey, we're lookouts, fight, guys coming, break it up, break it up. Nothing like that. He said they weren't involved in the fight. There was no confrontation. He was never stopped. He was never threatened. He was never intimidated. He walked back up with the Morris twins and with Christopher Melendez, who was the little guy down at the end of the street. The lookout in the getaway car. It's almost, it boggles my mind. Can you, thanks, Judge. The getaway car. Jacob Miller testified quite honestly that this was 3 years ago. Maybe he might have forgotten some things. He said that the car, at some point, when he first got there early, was probably up around there, right around parking lot. And then later he said the car was right around there. Really, that's the getaway car plan? You move it 5 spots. You don't move it down to Coulter to get away. You move it 5 spots, and then you get out of your car and you walk down to the fight to show everybody what's going on. The lookout theory, you know, God bless them, but it was dead on arrival. It's an attempt to work a theory to keep these people in the case. Which reminds me, I want to go back to accomplice liability in just a second, as soon as I'm done with the lookout. And then there's the lookout theory. That Markieff Morris, backed by his car, was acting as a lookout, okay? So that means he understood that Eric Hood was going to get hit in the head, run 150 yards, not keep going, but fall down. This is exhibit number 5. Right here is where Mr. Hood said everything happened. You see those buildings, the fence, the building to the left? You can't even see from where Markieff Morris was said to be by 2 different people. You can't even see what was going on down there or know what was going on. Here's another photo. The first 10 exhibits, and it's in the box, are going to show you vantage points from down there. I urge you to take a look at them.
Was that Exhibit 1, sir?
I'm sorry, Your Honor?
Was that Exhibit 1?
That was, I'm sorry, Your Honor, those were exhibits 5 and 7. When I say the first 10, they're not going to be numbered 1 through 10 because I don't think 1 was admitted or 2 was admitted. I believe they start whatever they are. Timing. The great thing about a jury is you catch everything, or at least we hope that you catch everything. One person probably misses something. 2 people maybe miss a little bit less, but also miss something. 4 people, again, it's a continuum. But 11 people and 8 that sit on the jury usually catch everything. Remember when Mr. Hood said the game started at 6 o'clock? And it usually lasts around 75 or 80 minutes or 90 minutes, right? So that means that the game ended probably around 7:20, 7:15, and the call from Alonzo Hickerson was at 7:29. Markieff and Marcus Morris were outside right after that basketball game. They weren't out there hanging around. They were out there right after the basketball game. From Eric Hood's own words, whether he's correct or not, I frankly don't put a lot of credence in what Mr. Hood says, so I don't know if he's right about 6 o'clock or that basketball games last 75 minutes. But if he does, and he's right, Eureka Sherrod also said, she made a 911 call at 7:34. She said, a fight happened about 10 minutes ago. Miller and Halal, Sherrod came in right after the game ended, and we went out right away. There was no lounging around out there. This was right after this game ended, within 90 seconds, 120 seconds. You can do the math. They were not lounging around and waiting out there. This happened right after the game ended. I forgot to talk about one instruction, and I'm going to go talk about it right now. Accomplice liability. Accomplice liability. You have to have evidence that a defendant solicited or commanded a criminal act, or that they aided or agreed to aid a criminal act, or they provided the means or opportunity to do so. There is no testimony, there's no evidence to that effect whatsoever. You listen to this case, there's no evidence to that effect whatsoever. Mere presence. Guilt cannot be established by a defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. What does that mean? The case that the mere presence instruction is based on is a case called State v. Noriega, just like the guy from Panama. And again, maybe some of you on the jurors, I look at you, know who Noriega is, and maybe some of you don't. I'll let, if you get back into the jury, fill it out. But I want to read something from Noriega, because I think it's telling here. And I told you, when I first spoke with you, that you were going to have, sometimes the instructions are difficult cognitively. So in Noriega, the Arizona Supreme Court says, we turn to the subject of the mere presence doctrine. We have not found an Arizona case which discusses the doctrine in depth, and we believe its importance and utility in criminal jury trials have been overlooked. This is particularly true in the context of accomplice liability, where the potential for juror confusion as to the requirements for the imposition of liability is significant. Going on, we believe, for example, that a question could arise in the mind of a layperson. And unfortunately, you're lay people. We're ostensibly professionals, so you're the laypersons that are on the jury. We believe, for example, that a question could arise in the mind of a layperson whether merely being present at the scene of a crime could create some type of criminal liability, especially in the context of a lay perception of what constitutes an accomplice. To illustrate, suppose a pair of young people are lounging on a corner when one announces he is going to throw a rock at a passing vehicle. The companion, without comment, remains with the actor until that person chooses a vehicle and throws a rock at it, damaging the vehicle and injuring its occupant. The companion may have silently approved of the actor's deed and may have even remained at the scene with a private resolve to aid the actor if needed. He may also have demonstrated what would be considered a consciousness of guilt by leaving the scene with the actor after the fact. Yet under these facts, the companion is not criminally liable. Facts and investigation. Okay, I don't know. It's when I first came in front of you people, I said to you, we don't know you from a hole in the wall. We fervently hope and we fervently pray that you will do the right thing, that you will see the case the way we see it. and they go apply the law and the instructions the way the judge is instructed. That's all we can ask for. We can't know you. And I don't know Detective Santos. He seems like a nice enough guy. But think about the investigation in this case. Think about the 13-minute gap with Eric Hood. Eric Hood, in the 48 hours after this incident, lied 9 times. Lied. Lie. 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 And then he gets a call. And we have no idea from whom. From his lawyers, but who was on the call? Detective Santos told me he could have asked those questions. Who's on the call? Eric. Was it Alonzo Hickerson? Eric. But he didn't follow up at all. All of a sudden the story shifts. Markieff Morris, instead of being involved in the fight, is now 200 feet away. Detective Santos, that's puzzling, but doesn't warrant further investigation. Doesn't warrant further investigation. You deserve better than that from the Phoenix Police. These people deserve better than that from the Phoenix Police. We rely on them to do a comprehensive and diligent investigation. There were dozens of calls with Alonzo Hickerson. You heard 2 people say that they were solicited to lie in front of you. We have more investigation of Gerald Bowman's bandana than we do of Alonzo Hickerson's statements. Where is Alonzo Hickerson? You ask the question, could he find these, could he issue subpoenas, could he do some investigation? Who's in charge of that? It's Detective Santos. Where is Alonzo Hickerson? What have you heard about the investigation regarding his taint in this case? Nothing. But, by golly, no holds barred that night and the next morning trying to find out whether Gerald Bowman ever wore a bandana. The call with Mrs. Morris. We know because everybody has said that the Morrises, they were going to see Coach Greg, and they had players there. But they're telling you that Mrs. Morris told the kids, the sons, that Eric's going to be at the game. There's no testimony to that effect. Wouldn't you like to know what was on that 13 minutes of missing tape from Eric Hood? He's the only one that controlled that. He had complete control of a 30-minute call, and we only have 17 minutes of it. On the 17 minutes, what we have is him telling Mrs. Morris, I know you didn't have anything to do with this. I know you didn't know anything about this. Markieff had nothing to do with this. But what about the rest of that call? You told the guys that I was going to be there. No way. I would never tell them you're going to be there. They don't even know that I talk to you anymore. You are persona non grata to them. You are a pimple on the backside of a pachyderm, Eric. They don't care about you. I would never have told them that you were going to be at a basketball game because then they would know I'm talking to you. But we don't have that because he had it and we didn't get it. That's reasonable, though, in and of itself, among so many other things. Sharika Sherrod, $20 million. I'm going to be a witness. Laugh out loud. I'm going to be driving that Jaguar, or whatever the car was, Rolls Royce. Are you kidding me? LOL. You should be offended by that. Absolutely offended. But put that to one side. Sharika Sherrod had multiple versions of what happened. We know that Joe Murray was outside. He didn't see anything in the grass. We know that she said a bunch of people were out there, maybe taking pictures, maybe doing whatever. They didn't see anything in the grass. 37 people were interviewed by Detective Santos. Not one of them said that anything happened like what Sharika Sherrod said. Not one of them. Not one witness said that what happened, what she said happened, happened. And what does he do? He doesn't even follow up. He doesn't even go back and ask her, hey, I've talked to 37 people and none of them say what you said. You know why? Because journeyman, right? Almost hard for me to say. But he had a theory. He decided this is how it happened. And anything that supported his theory, that was okay. And anything that might go against it, no way. Not going to look into that. Sharika Sherrod, 37 people say you're blowing smoke up my backside. I don't care. I'm not going to go back and talk to you. You deserve better than that. Criminal defendants, not just these guys, any criminal defendant in a case deserves to have a legitimate investigation. Their lives are at stake. Their liberties at stake. You deserve to have this done right. He's the one that said he was the quarterback. He's the case agent. I'm not going to get into football analogies, but if your quarterback is dropping the ball, then the whole team goes down the tubes. You let all of us down. A few things as to Marcus Morris. Okay? He's not my client. He's the brother of my client. Initially, I think you're hard-pressed to believe almost anything that Eric Hood says. You get to make that call based on credibility, bias, motive, whatever. I think you're hard-pressed to believe anything that he says other than there was a fight and his nose was fractured. Right? Beyond that, he needs, in order to have any money in this case, Julius Cain, you heard me talk about Julius Cain. I've got nothing in common with Julius Cain. Julius Cain is beneath me. Julius Cain is a peon. Remember when I asked him, well, if Julius Cain was the only guy you were suing in this case, really would be no money in it for you. Well, I don't even know what you mean by no money in it for me. Are you kidding me? Really? You saw the texts. $7 million, $10 million. Once we come up with, where they're going to start negotiating for the big bucks, he knew what Gerald Cain was worth. He thought of Gerald Cain as a peon. I don't know that anything that he says is credible, other than he was in a fight and his nose was fractured. But he needs to keep one of the Morrises in the case. And everybody, every witness says, including Good, eventually says, after lying 9 times, Markieff was 150, 180 feet away. Had nothing to do with this. But what did the 2 independent witnesses say about this? Miller and Blau. Marcus was not in this fight at all. When we saw him, one of them saw him the entire time, one of them saw him when he got down to that Ramada or a little past it, and Marcus was 20 or 25 feet away. So the only person that you have saying that Marcus was involved in the fight is Sharika Sharad, who, would you rely on anything if Sharika Sharad was the one that was providing support for you on that? So there's Eric Hood saying, well, yeah, Marcus was still involved. Marcus was still involved. I heard Julius Cain say, move, he's getting up. This is where 11 jurors and 8 that in the box, when you end up deciding this case, where we fervently hope that you listened and caught what was happening. When Gerald Lackey, not Gerald Lackey, I'm sorry, Kerry Lackey, Mr. Lackey was standing up and asking questions of Mr. Bowman. He showed him a photo. You saw the photo, it's going to be back there. And he went through, do you know this person? Do you know this person? He pointed to Christopher Melendez. And what did Gerald Bowman say? That's Muta. That's his nickname. Who's Muta? Christopher Melendez. I don't believe that Julius Cain ever said, Mook, Muta, come on over here, he's getting up. I don't believe that. But knowing what we know about Alonzo Hickerson, knowing what we know about the $20 million, the $7 million, that money changes everything, knowing we know about the taint of Alonzo Hickerson, and you saw Eric Hood change his testimony on the stand. He was changing his testimony as it fit his theory on a regular basis. I don't believe Julius Cain ever said Mook or Muta or anything like that. But it would be easy for Eric Hood to say, you know, I know Christopher Melendez was down there, or something to that effect, and I heard Muta. But it's easy to say Mook, because he knows that that's his nickname. I don't know that it happened or not, but I do know that there's a basis for him to lie about it. Remember back when the judge told you about charges, and she says you don't mean anything, people get charged all the time, and I told you that's not true. That is not true. Charges ruin people's lives. Charges ruin people's lives. Charge in a criminal case can be based on lies, it can be based on greed, It can be based on inadequate police work. I mean, really, do you believe Eric Hood, when he came in here and said, oh yeah, that's Gerald Bowman over there, he's sitting next to his lawyer. You could have identified Gerald Bowman. We came in, I stood up, Mr. Eckstein stood up and said, I'm Tim Eckstein, this is my client Marcus Morris. I stood up and said, I'm Jim Bellinger, this is my client Markieff Morris. And Mr. Lackey stood up and said, I'm Kerry Lackey, this is my client Gerald Bowman. And then Eric Hood got up there and said, oh yeah, that's Gerald Bowman. You could have identified Gerald Bowman. That's what that's worth. Sometimes charges come because of just inadequate police work. Well, we'll just throw a bunch of stuff on the wall. We'll let you figure it out. We'll let you figure it out. I'm going to sit down in a couple of minutes. I've been going on probably far too long as it is. And Mr. Bailey's going to stand up and he's going to do a rebuttal for the state. They have the burden of proof. They get the last word. Both of these county attorneys are good lawyers and they're doing their job to the best of their capability. But in this case, they're wrong. They're just fundamentally wrong. They're fundamentally wrong about what they're going to ask you to do. They're categorically wrong about the evidence. Based on the lack of evidence and the investigation in this case, and all of the contradictions that Mr. Eckstein went through, and the testimony of Miller Bilal, and the taint of Alonzo Hickerson. What I want you to think about when Mr. Bailey stands up is I want you to think about that taint. Can they purge that? I don't think they can. I want you to think about the text messages. $7 million if we keep the twins in this case. $20 million. I'm going to be a witness. LOL. And now I come to what is the most fascinating question in the entire case. And one of you asked it. I don't know who it is. We'll never know who it is. One of you asked the most compelling question in the case. Did Julius King or Christopher Melendez ever say that these defendants were involved in that fight that night? And for reasons that we can't get into, evidentiary reasons and testimonial reasons and a number of other things, it's a fascinating question, and you were able to ask it. You asked it. And then we had the 10 minutes of white noise with the judge. You remember that? We're all up in front of the bench. The white noise was on. You would ask the question. You wanted the answer to the question. And we talked about it. And we asked the judge. We back and forth, back and forth, back and forth. And what the judge is doing up there is trying to make a decision so that you get the most accurate and fairest information that you possibly can get. So the question was, did Julius King or Christopher Melendez ever say that Markieff, Marcus, or Gerald Bowman were involved in this? And finally, we came out of the cloud of white noise, and she asked the question of Detective Santos. And you watched him. He did not want to answer that question. He did not want to answer that question. He dissembled, well, they didn't say so in their own words. And Mr. Eckstein stood up and said, what do you mean in their own words? They've never said that these gentlemen were involved in this. King and Melendez pled guilty because they committed the offense. And Santos finally said, yes, Julius King and Christopher Melendez have never said that these three gentlemen were involved in this fight. It was a remarkable question. And again, for reasons we can't even get into with you, not one that we could have likely asked. But you could ask it, and you did. We are now, this is the most critical part of the whole case. This is the part where people like me and Mr. Eckstein and Mr. Lackey, we dread this. It's completely out of our hands, right? We have nothing left to say. You, the judge, is no longer the most important person in the room. I'll take that back. You have always been the most important people in the room, but the judge is right up there, right? Right now, we're done. We have nothing else to say. Not the judge, not the lawyers, not the police, nothing. You are the people, as a collective body, that are going to decide the fate of three people, based on the instructions and what you saw and what you heard. Their fate is in their hands. We can only hope, we can only implore ourselves that we've done enough. With incredible humility and fear that we've done enough to ask you to find them not guilty. I'm asking when you get your jury verdict, paper, I'm going to find Markieff Morris not guilty. I'm going to ask you to find Marcus Morris not guilty and Gerald Bowman not guilty. Thank you for your attention. Thank you for your attention. And thank you for your respect for the process, both up until this point and until the judge says you're free to go, your service is over. Thank you.
Thank you.